All right, and it's being recorded. Welcome, everybody. We're glad to have you here. We have some returning guests we've had many times over, attorneys from New Media Rights, particularly Erika Lee, who's talked to us many times about some of the considerations that you need to keep in mind as a startup who's launching your first company or your new company. And she's been doing this a long time. She knows a lot about it. We have another attorney with us today, Deanna. Is it Deanna?
Yeah.
Yeah, Deanna.
And I'm a student.
Student.
Almost
Yes,
an
almost
attorney.
attorney, almost attorney.
There. Yeah.
So congratulations. We're happy to have you. So good. So we'll just go ahead and get started here, and hopefully we'll not too many more people will be coming in dinging. But if you do have any questions, either at home or here, just let us know and we can answer them as we go. And I'll pass it over to you and let you take over.
Thank you. All right. Hello, everybody. Hello, everybody at home too. So this is legal considerations for startups. I'm Erica. This is Deanna. And to kind of get us started here, there we go. I'm going to talk a little bit about your rights. Just get rid of some of these. No? Okay. So, a little bit about our organization, who we are. There are kind of like three big things that we do. But first and foremost, we are a clinical program at California Western School of Law. So we're downtown. And one of the big things that we do is provide direct legal assistance on a free and reduced fee basis. And then we also provide some educational videos and guides on our website. And then we engage in some public policy work as well. We recently submitted some comments to the Copyright Office on their study on artificial intelligence, right? And how, they should apply copyright law to AI. So that's kind of a little sample of some of the policy work that we do. But as far as some of the specific services that we offer, in case you're interested, we primarily provide preventative transactional legal services. So what does that mean? Well, first and foremost, it means that we don't do litigation work. So there's that. But we really try to get in at the early stages of any particular project that you might be working on and help you kind of spot different legal issues that are maybe active, like currently happening, or that you might run into in the future, and we can help guide you to avoid those legal issues, right? So a couple of things up on screen here in terms of some of the common issues and services that we provide. First and foremost, preventing and triaging copyright and trademark issues. This is probably one of the bigger things that we do. So you might be thinking about, okay, like ownership and licensing. Do I own the copyright or the trademark rights to this thing that I've created? And if I don't, right, will it prevent me from moving forward with my project? Or do I have to take certain steps before I can go any further on it? We are known for our work related to DMCA takedowns. Has anybody ever heard of the DMCA before? No? Okay, one maybe over here. So the DMCA stands for the Digital Millennium Copyright Act, and it is basically a section of copyright law that does a lot of different things. But one of the main things that you probably have heard about in more popular culture is it allows copyright owners to take down allegedly infringing content from the internet without having to file like a formal lawsuit, right? So it can be kind of a quick and efficient way for copyright owners to enforce their rights. So we are known for our work defending against unlawful takedowns. So using defenses like fair use to help fight against those types of takedowns. Cease and desist letters and demand letters, right? We can assist kind of triaging that. And I think the biggest takeaway is, if you ever receive a cease and desist or a demand letter, do not ignore it, right? Pay attention to it. Don't just ignore it. Contact an attorney immediately, because most of those letters have some pretty strict like timelines involved. And so even if at the end of the day, the strategy is, oh, we're not actually going to comply with these demands, you still need to try to abide by those timelines and make sure that you're not going to accidentally get yourself involved in some litigation there, because cease and desist and demand letters are kind of like stage one of that whole process. What else? Contract review and drafting services. This is another big thing that we do at New Media Rights. But I think important to remember here is that we are based in California, right? So we can really only advise on California-based contracts. So if you have a contract that's been presented to you that is, based out of state or something like that, we might be able to only provide some like limited guidance on that front. But yeah, if you're presented with a contract or you need a contract drafted, right, a good step would, be to reach out to us or another attorney. Terms of use and privacy policies, you may have heard of these. Terms of use are sometimes referred to as terms of service, or a EULA, end user license agreement, if you're into video games. Those can be particularly important if you are doing any sort of online business. They basically lay out kind of the rules of your platform, right? And what you want your users to do and not to do. And also, privacy policies are particularly important in California. California has some pretty strict privacy related laws. So if you are collecting and handling any sort of user data, you have to be very transparent with your users about what you're collecting, how you're using it. Are you like selling it to other institutions, things like that, right? And then we also provide some counseling on privacy and data aggregation issues, in addition to providing some assistance with handling some online consumer disputes, right? If you're selling anything on Etsy or Amazon, right, there's plenty of different types of skirmishes that can arise in that context, right? So those are just a couple of ideas of some of the services that we provide, some of the issues that we've handled before, to give you kind of a sense of what universe we're going to be in today. Okay, I also have a slide up here that just contains some of our resources. We have our book, Don't Panic, which is basically a guide that's written in plain English, easy to understand and digest, directed towards small businesses and creative professionals. So some of the things that we'll talk about here today are also in this book. Yes.
You guys work with large companies?
Occasionally, yes, we do work with large companies. It just depends on the scenario and the particular issue at play. But yeah. Let's see. We also have the Fair Use app, which is kind of designed more for like video creators, but it can also be a useful tool if you're using third-party content that you didn't create yourself at all, and you're trying to figure out, can I use this, right? You can check that out in addition to some of our guides and our YouTube channel, which is quite fun. And you can find all of these resources at newmediarights.org. So feel free to check those out. Okay. Now we'll get to the meat and potatoes. Our focus today, we don't have a whole lot of time, so we're going to kind of focus on common areas where it can be easy to make mistakes. Let's see if I can minimize that. Perfect. So we'll talk about copyright, we'll talk about contracts, and then we'll leave a little bit of time for Q&A, and I'm happy to stick around a little bit later and answer other questions as well. But important, we can really only talk about like big picture and general concepts. So if you have a specific legal question about a project or your startup, right, please kind of don't ask that in front of a room full of people, right? For confidentiality reasons, it's really difficult for me to be able to answer those questions. But feel free to write in any specific legal question that you have on our contact form, which I have up on screen down here. But you can also, if you just go to our website and hit the contact tab, you'll be able to find the form there. So the only other thing I want to mention is, I think maybe if you could hold some of your questions till the end, because chances are we'll probably cover exactly what your question is on the next slide, right? So hold your questions till the end, and we will do our very, very best to try to answer those for you. Okay. Ooh. So first slide up here, I have this big question. When do I need to talk to a lawyer? This is a a pretty common question. And so I have a couple of instances here of when it might be a good idea to start thinking about, okay, maybe I should talk to a lawyer. So if you're selling a good or a service, you might be thinking about things like your logos, your branding, names, right? It kind of falls under the purview of trademark law, right? There are protections available to protect things like your logos and maybe like a particular product line you might have. You might be thinking about patents and trade secrets, right? Have you created some sort of new way of doing things, some innovation that you want to try to protect? Or trade secrets are basically anything that derives its value from being kept secret, right? So classic example is like the Coca-Cola recipe. So obviously there's some value in keeping that recipe, secret so that other competitors don't try to recreate it and cut into your market, right? If you have an interactive service at all, that's a good time to reach out to an attorney, particularly if you are allowing users to kind of like submit stuff to your website. So for example, any type of social media website, if you're, maybe working on starting the next Facebook or Instagram, right? There is liability related to content that users post on your site, right? If it's infringing, that site could potentially be held liable for things like copyright infringement. But lucky for service providers, there are some protections that you can put in place to make sure that you're not held liable for those types of claims. And then also, if you're engaging in a particular industry, like if you're doing anything related to the healthcare field or the environment or food, right? Those types of things, there are kind of very specific laws involved in those areas that, you might want to talk to a specialized attorney, right? Okay, so there's that. But also, if you want to work with somebody else, right, whether that's a team, a contractor, just like another person or some other entity, that's also a really good moment to talk to an attorney about the best way of going about hiring that person, right? Because you're thinking about, okay, from an intellectual property standpoint, who owns what, right? Maybe this person is bringing content to the table or they're bringing knowledge to the table, and you want to be able to kind of draw some boundaries in terms of, okay, if this person were to walk away, are they able to take that knowledge with them? Or do we want it to all stay with the company, right? You're going to be thinking about contracts, right? You should always have contracts in place when you want to work with another person. You're also going to be thinking about employment concerns here. In California, in recent years, it's been a lot more difficult to hire folks as independent contractors, particularly if they're doing kind of the work that your business is kind of designed to do. So it can be really important to get some advice on, should I hire this person as an independent contractor? Should I hire them as an employee, right? Part-time or full-time? Because you don't want to run afoul of California labor laws, right? And then, right, finally, I'm starting my own web service, my own app, right? Again, you're going to be thinking about things like the terms of use and privacy policy. You're going to be thinking about the DMCA, the Digital Millennium Copyright. Again, you're going to be thinking about the CDA, which is the Communications Decency Act, right? Which is basically an area of the law that prevents certain lawsuits against services, online services, based on like what their users are posting and doing, right? And there are other ways to kind of reduce risk if you are venturing into the web services field or you're creating an app of some sort related to those services. But the point, I think, here of this slide, at the end of the day, if you only take one thing away from this, is that you should talk to a lawyer early, right? Particularly before you start to invest a ton of money into something, or, before you're trying to work with other people, or, launch that product, right? Before you take that next step, that's a good moment to talk to a lawyer and make sure that all your I's are dotted and T's are crossed so that you don't run into some risks there. Okay, so with that, I'm going to hand it off to Deanna, who's going to talk about copyright law.
Thank you, Erica. So under Title 17 of the United States Code, copyright law essentially provides owners of copyright exclusive rights to distribute the work, reproduce the work. They're able to display it. They can also create derivatives of that work, which would look like sequels based on original works. If you're thinking like the sequels to Harry Potter books or the Hunger Games. Under copyright law, people are also allowed to perform their work, which is seen with different displays of theatrical performances or musical performances. And copyright can really offer some great benefits, but those rights do not last forever. The life of copyright lasts the life of an artist plus 70 years, or if it's a corporate author, life is 95 years from publication or 120 years from the creation, whichever one happens first. And not everything can be protected by copyright. Copyright law only protects expressions that are first fixed in a tangible medium of expression. That means they're saved in some type of tangible format. And secondly, that they're the result of some type of independent creation, meaning that they have some sort of originality attached to that. And that's typically a pretty low bar. And additionally, the expression should also fit within the category of a protectable subject matter, and that can include books, movies, scripts, songs, musical compositions, photographs. And one thing to note is that ideas are not protected by copyright. The distinction between ideas and expressions is important because ideas can be reused by other people without permission, but the specific expression of that idea cannot be used or reproduced without permission of the original copyright owner.
I'm going to interrupt you just for a second
Yeah.
here, Deanna. I just want to make sure it sounds like there's a little bit of feedback, and I just want to make sure that it's
Yeah, no problem.
down. There we go. Okay, everybody at home, can you still hear me? Maybe get a thumbs up or something like that. Can they hear me at home? See, now I can't hear if they can hear me. Yes, okay, good. All right,
Perfect.
it's all you.
Yeah.
All right, then hopefully that will take.
I can hear everything. I can hear fine.
So just one example about how ideas cannot be protected by copyright. So say there's the idea of a social media website. That idea of creating a social media website is not protectable. But what is protectable is the code used to create that specific site, such as if you're thinking Facebook and Instagram, that specific code cannot be copied without permission. And so like you can freely create your own social media website, but you need to create your own expression of that specific code in order to get your own protection of that idea. And I think I went a little too far ahead.
You might have to just hit the left key.
Okay.
There's.
Perfect. So there's other works that are not able to be protected under copyright. This includes facts, general facts such as the date the Declaration of Independence was signed, or the fact that Marilyn Monroe likes to visit the Hotel Del, or that Beyonce's from Houston, Texas, don't fit the originality requirement under copyright law in order to have protection. Additionally, titles, names, short phrases, and slogans, they're also too minimal to meet the requirements of a work to be protected under copyright, but those can actually be protected under something else, which is trademark. And copyright also does not extend to protect procedures, processes, systems, other methods of operation, simply because it's also an issue for patent work, which is an entirely different subject that has its own requirements and procedure to get that done. Additionally, when works enter the public domain, it means that the work is no longer protected by copyright and it's freely available to use. And so generally anything created before January 1st, 1929 is in the public domain. And some things that are in the public domain include Shakespeare's plays, the Bible, the Happy Birthday song, So those are freely be able to be used by other people. And as previously mentioned, copyright lasts the life of a creator plus 70 years. And an example of this is just recently in January, the copyright for Steamboat Willie officially expired. So that copy, that image of Mickey Mouse is now in the public domain. And additionally, federal government works are not protected generally, but because if an employee of the federal government is creating something in their scope of work, that is also considered in the public domain. So for example, if the official White House photographers taking pictures of the president out getting ice cream, those are some images that are freely able to be used and redistributed under the public domain. And kind of a policy reason behind all of this is because we want people to really build upon the ideas and information conveyed and gathered by other people. And it really encourages the creation and promotion and progress of the arts and other innovations and things of that nature. So why is it so great to have copyright protection? Really, the big benefit is that you own the rights and have the ability to control those rights of your work. And you don't have to register the work with the Copyright Office. It's not required to receive protection. The work receives protection automatically as soon as you're done creating it. And when you do register the work, the main benefits are that you first get statutory damages, which is a monetary recovery. And you're entitled to receive anywhere from $750 to $30,000, and even up to $125,000 if the infringement is willful. And so that means there's a lot of money on the table that you possibly are able to receive if you do register your copyright. And secondly, you are able to recover attorney's fees in your lawsuit. And additionally, some benefits with that lawsuit is that you're able to actually file the lawsuit in a federal court. And registration essentially just puts the world on notice that you're the original owner of the copyright. And that it essentially puts people on notice. So as the copyright holder, you also have the ability to grant a license for other people to use your work. And a license is a grant of permission to exercise your rights under copyright. And an example of that is when you upload a video or a photo onto different platforms like YouTube and Instagram, you're giving them a non-exclusive license to use your content. And then where you also have the ability to give an assignment of your copyright, which is a permanent transfer of your work to a different third party. So what if I want to use someone else's content? So just because you use someone else's content and you post it on your platform, you put your logo on it, it doesn't mean that you now all of a sudden own it and you are granted the rights and benefits of a copyright holder. If you ever want to properly use somebody else's content, you need to get permission from the copyright holder, which can be in the form of a license or an assignment. You can use it under fair use, or you can have the work be found in the public domain. And so I talked about, getting a license. What does this mean? How do you really obtain a license? Generally, you need to have contact to the copyright holder directly to get that permission. However, there is a lot of openly sourced content out on the internet that you can use. We say that open content is there and it has a broad license attached to it. And for example, there's the platform Creative Commons, which is a common platform for obtaining different content under an open license. However, just because there is an open license, it doesn't mean that it's not protected under copyright. It just means that the copyright owner has opted to make their content more easily available, but it is still protected under copyright. So you cannot claim that open source content is proprietary to you or your company. For example, if you use open source code, you cannot attempt to enforce the copyright on that code if somebody is an alleged infringer, but they ended up using that same base of code from open source. Because it's under the Creative Commons and under that license, you cannot claim it as your own because it's protected under copyright. And other ways you can reuse content without getting a license is through fair use and public domain. So fair use allows the public to use portions of copyrighted work without permission from the copyright owner. And there's a 4-factor balancing test to determine whether or not something is likely going to be like fall under the category of fair use. And we're not going to get too much into fair use today, but if anyone has like specific questions about fair use or reusing content in general, please feel free to reach out to New Media Rights. And hopefully like we can answer your questions and get you some answers. And additionally, with the public domain, works can be freely used by anyone for commercial or non-commercial purposes without permission from the original author or creator. And one thing to note is these are actually defenses of copyright infringement, but it's important to keep these in mind when intending to use third-party content. And that's all from me for now. I'm going to turn it back to Erika for the contracts portion of the presentation.
Thank you. So does everybody understand what Deanna was talking about when she was mentioning like the open source content, right? And like, you know, if you go to GitHub and you get code that's openly or openly licensed, right? You have that ability to use it, but you can't necessarily enforce that like a copyright owner would. So it's just a cautionary tale, right? I see this a lot where people are like using open source code as the foundation for their app or something. And they're like, oh, this code is proprietary to me, right? And I'm like, well, no, actually, because you used code that somebody else created, right? You can still use it. It's just that you have to be careful if somebody else is using that same code too. You can't like prevent them from doing that. So it's a very kind of like specific scenario. Yeah.
So
Yeah.
if you're building an app or something and you're using an open source, something is part of it,
Mhm.
is everything in the app no longer, you can't copyright any of that anymore?
Good question. So the short answer there is no, that original content that you are adding to it can be protected. Yes. It's just that the stuff that already existed, you can't claim ownership to that stuff, right? So it kind of like bifurcates at that point, right? So yeah, very good question. Okay, so let's talk about contracts. A few kind of big picture concepts about contracts. First of all, contracts just describe a legally enforceable relationship between two entities or two people or a person and an entity, right? And I think there are a couple of things that aren't necessarily like immediately apparent to folks who maybe haven't seen the life cycle of a lot of different contracts. And the first thing is that, you know, just because you have a contract, right, that doesn't necessarily mean that people aren't gonna, you know, do what's written, right? Like they could just do bad or do good, right? And you know, things can go really poorly if there's a contract, but things can go really well even if there's no contract, right? Does that make sense? The point is that like a contract itself isn't like magical. It's not going to like magically force somebody to do something or to not do something. And so, but we know, right, that contracts are legally enforceable. So it's very important to have a contract in writing, right? Don't just rely on like verbal conversations or just email, right? I get this question a lot, like, oh, doesn't my email communications count as a contract with this person? And the short answer there is that, you know, emails can be really great to keep a record of communications, but it's a lot more difficult to show that an email would be considered a contract. It's very difficult to argue that because a contract is kind of made up of three basic elements, right? You have an offer, you have the acceptance of that offer and those terms, and then you also have something called consideration, which is basically a fancy legal term for like a bargain for exchange between the two parties, right? So somebody is getting a benefit or they are suffering a detriment of some sort. They're like giving up something that they didn't have to, or they're doing something that they didn't have to do, right? And so when you have just an email thread, the email communication causes a lot of issues around whether the parties actually accepted the terms of that deal, right? Because traditionally acceptance is shown by signing the contract, right? Putting pen to paper. And with an email, it's a lot more difficult to show, right, that this person actually agreed. So it's an issue of acceptance. It can be possible, right? But it's a lot harder to prove. Don't start work until you have a signed contract, and don't allow someone to start working for you without a contract, right? So that everybody understands what their responsibilities are, what benefits they're getting, if you can. But that being said, avoid what we like to call Frankenstein agreements. What do I mean by that? These are basically contracts that you've brought to life by piecing together different things that you might have like pulled from Google, right? Like, oh, I went to this website and I really like this clause, I'm going to throw it in there. Or, you know, or it could be like, hey, I've got like a buddy and like he handed me this contract and I think I can use it, right? Careful there, right? Because contracts should be specifically tailored to your particular situation. You know, sometimes it can be a lot worse in that scenario to have a contract that's like a bad contract, or it doesn't actually reflect what you wanted it to reflect, right? In that situation, it's almost better to have no contract at all, right? So avoid those Frankenstein contracts to the extent that you can, right? A couple of other big picture concepts here. A lot of contracts are presented as like a take it or leave it situation, right? But like at the very least, if you can't negotiate anything, which usually you can, you should at least understand what it is that you're signing, right? So and understand like how it affects the other work that you might want to do, right? Particularly when it comes to intellectual property. You should understand like, what rights am I giving up? And does that affect my ability to continue working on this or to do something new, right? I think, you know, in addition, it is really worth discussing your contract with a lawyer. That's kind of the theme here, like, right? Don't be afraid to talk to lawyers. But important, like particularly when it comes to contracts, because they'll be able to spot some red flags that maybe you're not even thinking about, right? I think the biggest problem that I've seen is people kind of rushing into a contract and then it kind of comes back to bite them because maybe they didn't understand what it said, or, you know, maybe they just didn't like take into consideration all the different risks that might have been involved, or weren't like thinking prospectively or thinking in the future. And when you work with a lawyer, right, they'll be able to ask you questions about, okay, like, what are you doing? Who is this other party? And like, what's the goal of this relationship? What are the expectations of both sides, right? And what are the deal breakers here? Like, what are your deal breakers, and how can we build in some protections to prevent those worst case scenarios and protect best case scenarios, right? So, you know, I'm always a big proponent of having folks work with an attorney, but it's difficult, right? Because entrepreneurs, you guys want to move quickly, right? And so it's really difficult for someone like me to come in and pump the brakes and be like, hey, well, hold on here for a second. But you know, so be prepared to kind of slow down a little bit if you're going to work with an attorney.
That's why we love attorneys, because
Yeah.
you guys, you keep your reality checks for us a lot of the time. Because if not, without you, we would all do Frankenstein contracts and just go without, you know, looking and jumping right in. I'm sorry to interrupt everybody.
Yeah.
I just want to let you guys know, there's pizza in the back. If you want to grab a slice while you're watching, you know, I know we're right in the middle of dinner time, so please help yourself to drinks and then. Sorry.
Excellent.
Yeah.
No, the all important.
Yeah. all important.
The food. If you feed them, they will come, right? So yeah, so right, at the end of the day, working with a lawyer can be really helpful. So another thing to keep in mind is that contracts and copyright work together. And in particular, contracts can change some of our basic copyright ownership rules. So keep in mind that the basic copyright ownership rule is, if you create some sort of expressive work, you own it, right? The creator owns what they create. That's the baseline rule. But there are ways that we can change that. We can get around that by using contracts. So what do I mean by this? Maybe it's helpful to kind of view this in the form of an example. Very common issue that pops up all the time is okay, I want to hire like a developer to help me code some front end stuff for my website. And make it look very pretty and nice. So ideally, right, you should have a contract with that person, number one, but they will be creating some form of like intellectual property at the end of the day. And so if you want to own that content, right, you have to make sure that you account for that with a contract, because this person is now creating this stuff, right? So the baseline rule says that developer, that coder, they own the work that they're creating. So if you don't want that to be the case, you can use a contract to transfer that ownership. Ideally, you would do that before that person ever starts typing or doing anything for you. But it can happen afterwards too. It's just a matter of what we call it, right? And if you don't have an agreement, like I said, this person owns some interest in the work, some copyright ownership interest, but you do too, right? Because you are working together to create this thing. This is what we call joint ownership, okay? And joint ownership is a situation that arises when two or more people create a work and they intend for their contributions to all make up this like unitary whole, okay? And the weird part about joint ownership is that each of those individuals owns 100% of the copyright. It's not like, oh, I own 50% and you own 50%. Each of us owns 100% of the rights. What does that mean? That means that person number one could go off and exploit the content any way they wanted to, and so could person number two independently. But they each owe each other their respective share of the revenue that they receive from exploiting that content, right? So that's where the issue comes in with a lot of businesses with joint ownership is like, yeah, no, I don't want to have to keep paying this developer that I hired as a one-off type situation to help me code some of my front end here, right? So it's usually like a boundary in the sense of, you know, sharing that revenue can be a big kind of hassle, right? So if you don't want to have to keep paying that developer, then you should have a contract to either make sure that their work is going to be considered a work made for hire, or you get them to assign their rights to you after the fact. Okay, so I just threw out two more terms here, right? Work made for hire and assignment. What the heck does that mean? What's the difference? So a work made for hire describes a type of copyrightable work that is not owned by the individual who created it. Remember our basic rule? If you create it, you own it. In this scenario, the person that creates it does not own it, right? So there are two ways to do this. You can either, the work is either a work made for hire if it's created by an employee, and part of their duties was to create this stuff, then the employer owns that content. Ownership vests in the employer rather than the employee, right? So that's the most straightforward way for a work to be considered a work made for hire owned by the employer. The second way is if the work is specially commissioned, right? So if I specially commission Deanna to create something for me, I would have to have an agreement with her in writing that specifically says that this content is going to be made a work made for hire. And then we both have to sign it, right? And then the ownership of that content, when she's done creating it, vests in me, not her. And this is kind of funky because this process has to happen like before the work is created, because the work made for hire scenario envisions a situation where nothing's been created yet. It's accounting for like future stuff that someone will create for you. Whereas an assignment, right? An assignment agreement is, like Deanna was saying earlier, a permanent transfer of rights, and it can happen after the work is created, right? It's thinking about things that have already been created. So yeah, like I said, assignment is another option if you like don't get a chance to do the work made for hire situation, or you didn't know about it until now, right? And you're like, oh my gosh, freaking out. I have stuff that someone created for me and now I don't know whether I own it or not. An assignment is another way to help transfer that ownership. There are drawbacks and benefits to both of these avenues, work made for hire or an assignment. For an assignment, it can be a little bit difficult to try to get those folks to assign their rights after the fact, especially if you're at a point where you've like launched the content or launched the particular copyrightable work. Because then, you know, they might see, oh, there's some value in this, and maybe I'll ask for some money from them or more money, you know, in order to transfer this work. So practically speaking, it's a little bit trickier to get that assignment after the fact. So the earlier you can do that, the better. There's also, not to get too into it, but there's also like termination rights associated with assignments where somebody could come 35 years from now and request the termination of that transfer. That's kind of rare, but I raise it because it is technically a drawback to an assignment. And with work made for hire is actually one of the big drawbacks is that if you just like throw in a work made for hire provision in an independent contractor agreement that you have with somebody, because I've just said, oh, like this might be the best way to do it, right? The problem is that that clause can actually trigger some labor code issues. What it does, and the labor code actually says this, it's like, oh, if you have commissioned someone in a contract to create a work made for hire under the federal statute, right? That person is automatically going to be considered a statutory employee under the labor code. Scary, right? Because you're like, no, I didn't hire an employee, I hired an independent contractor. Basically, what it means is that like that employer, the hiring party is responsible for obtaining like workers' comp, disability, and unemployment insurance for that independent contractor, which is a bummer, right? Like, especially if you're not in a position to be able to do that, right? And you didn't anticipate that. Now this probably happens all the time where people just throw in the work made for hire provision in an independent contractor agreement and maybe no one finds out, but it's something you have to think about kind of early on. And it's like, do I want to take that risk? Probably not, right? So that's kind of the biggest drawback, is that it does kind of cause some statutory employee issues. So it's really important to think through that, because sometimes that just means that having a work made for hire provision in your contract, maybe that's not the best choice. Maybe you do just have to get an assignment and you just do that right away with that person, right? Anyways, enough about that. But the point is that intellectual property, and particularly copyright, can be transferred. And you can do that with a contract. Okay, also remember, licenses are contracts too. Licenses are temporary grants of permission that allows particular individuals to do very specific things for a limited time or for a perpetual amount of time, depending on what the term of the license is. You can kind of work a license to do whatever you want to do in terms of granting permission. But it's also important to just remember, like, okay, am I promising this company that's hiring me, what am I promising to them? Am I promising an assignment or a license? And can I grant them either of those things, right? Do I actually own the rights to be able to grant a license? You want to think about like what kind of reps and warranties are made, right? Are we saying that this is as is and I'm making no reps and warranties about this material? Or are you making some sort of stronger promise? If you don't know what a representation and warranty is, again, like more legal jargon, sorry. But a representation is basically like statements of fact that are true at the time of signing an agreement. And the warranty part is a promise from you that it's going to continue to stay true. So for example, a lot of contracts will say something like, I represent and warrant that I have like the power to enter into this agreement, number one, and I also have the authority to grant the rights granted herein. So if it's like a copyright license and you are not actually the copyright owner, but you're granting a license, you're breaking that representation immediately, right? Which can get you into trouble in terms of it being considered a breach of the contract. So kind of complicated, but hopefully you're sticking with me here on the legal jargon. But also with any contract, particularly with licenses, you always got to think about, okay, who is this other party? Who am I dealing with here? Am I dealing with some major company who has a lot of leverage over me? Am I dealing with like an indie production company or like a smaller startup, or maybe it's an individual, right? each of these people have different interests and may or may not be open to negotiations. And it can kind of change the game here in terms of what's in the contract and what's not. Very quickly, other ways to like limit your overall exposure to liability include forming a business entity, right? That can be an important step to kind of protect and separate your personal assets from your business assets. We don't offer business formation services, but we have a lot of referrals to folks in our community who do and who can potentially provide either pro bono or low fee services. So feel free to reach out to us if you're interested in that. Just understand that we wouldn't directly be involved in that. Insurance is another good thing to think about, right? There's a lot of different types of insurance, but like if you are doing anything with heavy equipment or a lot of personnel and different activities, that might be a good moment to think about getting some like personal injury insurance that covers like bodily harm or property damage, right? If you're doing anything related to media in general, errors and omissions insurance is another good one to think about. It covers things like copyright infringement claims, defamation claims, other types of errors and oversights or negligence, right, that you might make in the course of creating content, sharing content, doing everything that you might do related to media of any form. Okay, wrap this up and I'll open it up for questions. So what? Like, what's the big deal? What happens when I break copyright law? Why does this all matter? What happens if I don't have a contract or just decide not to follow my agreement, right? Well, there's a number of different things that could happen. Cease and desist letters or demand letters, which obviously will demand lots of money from you, and they are pretty scary and threatening, right? It could result in DMCA takedowns, particularly for copyright, right? Where you have someone where all of a sudden you log on to your website or maybe your social media account one day and your content is gone and you're like, what happened here? That's, you know, tricky to deal with too. It could result in the termination of social media accounts like YouTube accounts. This is actually a really big deal for influencers, but also like any new business that's trying to market themselves, right? And get content out there to show other people what they can do. YouTube has like a 3-strike policy where if you've infringed copyrights like 3 times within a certain window of time, they will like suspend your account. They'll terminate it. So you lose all your content, you lose all your subscribers, you lose all your view counts. And again, that can be a huge deal if you're making a lot of ad revenue off of your content, right? That's gone. So that one hurts a little bit. And then finally, lawsuits, right? Which you never want to get pulled into a lawsuit. They cost a lot of time, money, and just like energy. They take years to resolve sometimes. So all of this is not meant to like freak you out, but it's just meant to encourage you to proceed with caution. And when in doubt, contact NMR or another attorney to get some help on any of these issues. So with that, let's open it up to questions from you all.
I have a question.
Yeah.
Thank you, by the way.
Of course.
So much.
I feel like I was talking a mile a minute, but that's okay.
No, it's good, it's good. So I'm glad you left enough room for questions here at the end, because I know, you know, at 7 o'clock, a lot of people will be having to leave, but
Yeah.
Getting appointments with you guys. So I know in the beginning, you kind of briefly touched on this. You offer low cost and free services?
Yes.
Correct? Okay.
Mhm.
So how do they take advantage of free services? Because I know that that's going to be the question I get all the time.
Yes, absolutely. So the best way to do that is to write into our contact form. And then we have like a referral box there where you can write in like how you found out about us. And I would in that box put that you are part of the rec. And yeah, this one right here, like I said, you can find that on our website. Mention that you're with the rec. And, you know, we usually like all of our consultations are usually free. So but it's just that if we end up doing any sort of work for you, it could also be free as well, but sometimes it might be low fee. It just depends on the particular situation. We also are funded by different grants. For example, we have a grant from the city of San Diego that supports work with local San Diego entrepreneurs So, that's more often than not, it's going to be a free services or consultation because of that grant from the city. So we love the city of San Diego.
They actually, we have their logo on like all their advertising for this because,
Mhm.
we appreciate they're like helping us put this on too. So
Yeah.
I appreciate them. We appreciate them. So basically they can go to your website, they fill out the form, make sure that you put the rec in there so that they know where it's coming from. And then usually you'll just get back to them and let them know. And you can even help with things like writing contracts and like all.
Yeah. Yep.
And I have one more question then, or did you have a question?
I saw a question over there, but
And then afterwards.
Okay.
Yeah, so, yeah, question, yeah.
Yeah, so when we fill that out, is it like an in-person thing or do we get like an email, like, how is it?
good question. So first contact is usually an email saying like, hey, thanks for reaching out. And we might ask you a few questions over email or something. But usually consultations with us happen over Zoom, right? It's a lot easier doing Zoom than having to have you drive down to our location and find parking downtown, which is a pain. But just depending on the situation, we might ask you a lot of questions up front in an email, or we might just like immediately schedule a consultation with you. It just kind of depends on the particular issue that you're presenting. Yeah.
Follow that. Is there a determination or how is it determined if it's accepted for the pro bono free stuff?
Yeah, so we like to just, as part of that, learn more about what you're doing. And like I said, with our grant from the city, it's a local thing. So we'll look at like where you're writing in from. We ask for some basic information from the contact form in terms of like jurisdiction. So like what city or state you're in, right? But from there, yeah, it just kind of, like I said, a frustrating lawyer answer. It depends on the situation and also what you need, right? Like if it's resource intensive, I can't guarantee that we'll be able to work together because we're a small operation. We have myself and Art are the two full-time attorneys on staff, but this semester we have 10 awesome, amazing legal interns, and Alyssa is one of our interns as well. So, it just kind of depends on our bandwidth, what exactly you need. But usually, right, like if you fall into that qualification of maybe our grant supporting the work, then it will potentially be pro bono. Yeah. And we also have a page on our website about like who qualifies for reduced fee and pro bono services. So if you just search like reduced fee on the website, you'll find that page, which kind of explains into way more detail how we go about determining that. Yeah.
Search what?
Reduced fee. Yeah.
I know there's some questions on the chat. Oh, sorry.
Yeah.
Go ahead.
Go one? Oh, no, go ahead. Let's say we opt for the reduced fee, does that give us a higher chance of a faster turnaround?
Oh, good question. Not necessarily.
Like for a contract.
Yeah, not necessarily. No, not like if you're opting for a reduced fee, as opposed to like saying that you could pay something that doesn't necessarily like bump you up or down our list of people who are writing in. We have a lot of people that write into us every month. Of course, when you offer free services, that's what happens. So we have some processes to try to, sort through that and everything like that. But our main point, and we say on our website, like if you write into us, you will get a response, right? Even if we can't work together, we try to point you in the direction of someone who will be able to help, right? So you can expect a response. It may just not be like the same day or the next day. It might take us a little while depending on what our backlog looks like. Yeah.
And I will say this too, so for all of you that are students, especially the entrepreneurship students, don't write in for questions that don't require attorney help, right? I mean, I know they're always say, ask an attorney, talk to an attorney. Yes, but that doesn't mean like questions about your idea or questions about like prototyping, things like that. Like that's, we have other resources for that, like really think about what you need to, what you need an attorney for, and then tailor that question to that. And I know there were some questions from online, right?
Yeah, we have some questions. Kyle can ask this question first. Kyle?
Yeah, hi. Thanks, Calvin. So thanks for the
I
presentation.
don't know how to do this on this
The
one.
touch
Oh,
screen.
yeah, sorry, I'm so not used to this. Sorry, guys. Okay, try
there we
that
go.
again. Go ahead, Kyle.
Okay, great. Thanks for the presentation. Very helpful. So I'm a student founder at the Rec, have a tech startup, And I'm asking this question because I'm assuming that some other tech startups might have a similar question, which is if you're building B2B software, do you, and you're not collecting personal information, do you still need a privacy policy? And, what might that look like for terms of use and privacy policy?
Great question. My knee-jerk reaction to that is yes, right? Because even if you're not collecting, if you're not immediately collecting personal information from like individual people, you might be touching data from that other business that is touching those users, right? And so again, in California, like transparency in terms of what your policies are with data collection and usage is kind of like better safe than sorry, right? So it doesn't hurt to have a privacy policy in place. Yeah. Good
Okay.
question.
And do you guys have any templates for privacy policies in terms of use?
So templates, no, not necessarily, because like I said, contracts should be kind of individually tailored to a particular situation. And so to give you kind of an example of why that's the case is there's a very big difference between a company that is doing maybe like a social media website and a company that has some sort of med tech smart device, right, that hospitals are using or something like that. And so there are very different degrees of risks that you have to account for. So we generally don't just provide templates to folks.
No breaking contracts, right?
Yes.
Yeah.
And now that being said, like we will, like after consulting with someone and taking them on as a client, we do create like template contracts for particular situations for that. Yes, yes, exactly.
And I just wanted to say, because I know some of you have other classes and classes that start at 7. If you need to take off, that's fine. If you need to stick around, we're going to be over at the rec in the other room if anybody needs to be working on their startup. And if you want to stick around and ask a few questions, we'll probably stick around to ask questions. But I know a lot of you at home need to go to your next thing. So bye. If you're, yeah. And the videos will be available starting tomorrow. Tomorrow, the next day, we'll have them up on our YouTube. Right, but yeah.
Thanks so much.
Yeah. And then there was another question, Calvin. Paige, you had also a question?
Yeah, I did. So at the beginning of the presentation, you mentioned that it's getting harder to hire independent contractors. And I just wondered what the reasoning is or what considerations there should be, because I think, for almost any startup, they're likely to want to work with contractors and can't really afford employees.
Yes, this is a very frustrating dilemma that I think everybody in our clinic right now has been working on this semester. So there was some legislation that was passed a few years ago called AB 5. You may have heard of it. And then most recently, there were some revisions made to that, right? So right now, what the law says is it kind of flipped how we determine whether someone's an independent contractor on its head, and it just has made it a lot harder because what that law says is that the baseline rule is that when you're hiring someone, you should hire them as an employee, full stop, right? Unless you can show like 3 things, right? It's called the ABC test. And one of the places where most businesses fail, right, is the requirement that says like, oh, is this person that you're hiring going to be doing like the work of the business that you're operating? Right. And that's where a lot of startups tend to fail that, because it's like, yeah, of course I'm going to hire an independent contractor to help me get this off the ground. I can't afford to pay employees right now, right? For many different reasons. And so that's kind of where some folks fall short. Now, that being said, there are like exceptions to that rule. There's like a whole different list of different categories of scenarios. So it's not to say that startups can't fall within those exceptions where they can hire someone as an independent contractor, but I raise that because it's a very significant like departure from what we're all used to in the state of California, because it used to be very easy to just hire an independent contractor for anything.
But people get around it all the time still, right?
Yeah, you can get around it. Like the kind of the classic exemption is like the B2B exemption, right? So where you're hiring another business to help you do something. However, the B2B exemption has like 11 different elements to it that you have to meet every single one, right? And they're still trying to like delineate. They're like, oh, we don't want just someone who would normally be an independent contractor, just like forming an LLC, and then they can do the same thing that the business is doing, right? So there still are like other requirements to meet to do certain things. Or like another classic exemption or a good exemption for us is for lawyers, right? Like if you're a lawyer, you can hire a lawyer on an independent contractor basis, right? So there are exceptions to that rule, but it's just kind of like a red flag for you all to think about before you like quickly are like, oh, I'll just hire a
Like
contractor.
we always used to do.
Yeah, exactly. Yeah, go ahead.
Entity is set up in a different state like Delaware or Wyoming, but you
Yeah.
could just here's it.
So it's less about like where the company is formed and more about exactly what they're doing and the power and control that is going on between the two entities. Yeah. So good question though, but not necessarily, yeah, doesn't really have anything to do with geography. Yeah.
I wonder if you have a novel idea and then to a research paper and then go to the technology transfer office, get it patented, and get it patented, is that true?
So a couple of different avenues there. Did you want to take a crack before I start answering that?
Actually not sure.
Okay. So there's kind of two scenarios that arise in that hypothetical, right? There's patent and then there's like kind of copyright. So like remember, ideas are not protected by copyright, but ideas can be protected by patent law, right? With patent though, it's a little tricky because a lot of patent requires you to not really like publicly disclose what your invention is or what your innovation is, right? So the idea of like writing a research paper, publishing it, and then taking the next steps from that could actually be harmful
Right.
to obtaining the patent. So the biggest thing to remember is if you are trying to like get a patent, right, is you don't want to go publicly disclosing that invention or idea. And that would be a good moment to like talk to either someone in tech transfer or like a patent attorney to figure out what the best way of going about protecting that idea is. Yeah, but if you're just like, oh, I have this great idea, and it's maybe not protectable by patent, but it might be protected by copyright, then yeah, you could write like a paper about it. And that paper is protected by copyright. Does that make sense? Yeah, I know it's like kind of a frustrating line to draw and figuring out the strategy there, but like I said, with patents, careful not to publicly disclose. Yeah, great question. Oh.
Is there a specific, like website or like a encyclopedia, if you will, like to see? Trademark or something?
Ooh, good question. Oh, sorry.
No, I'm not me.
Yeah.
Questions for you. Sorry. I'm just teacher mode. So I don't answer questions yet.
Yeah, most of anything that's been registered in the Copyright Office, you can actually search
Mhm.
through the copyright website. They have like a search database for that. So you can you can look it up, and the copyright website has like a lot of really good information and guides about even how you can self-register. You can look it up and you can see the different laws associated with copyright right on their website. And I believe the same goes for trademarks and even with patents.
Mhm.
You can look them up through their database.
Yeah, exactly. And those are really useful tools. A little bit clunky sometimes, and they can be difficult to actually find what you're looking for. But yeah, those are fantastic resources. Copyright.gov, that's the Copyright Office. And then the USPTO, if you just search USPTO Trademark Office, you'll find their trademark searches there. But yeah, excellent
Go
resources.
down the rabbit holes.
Yeah.
Fun afternoon.
Oh, I've done that a few times and come up dry.
Yeah,
But,
exactly. Yeah.
but that doesn't mean it's not protected, at least on the
Yeah,
copyright
right.
standpoint. If you don't
Yeah.
find a registration record,
Yeah.
it might still be protected. It's just that, because like Deanna said, once you fix your work, like if you're creating something in 2024 and, it's automatically protected. But for some stuff, you did have to register at various different times in history or like renew the copyright. And so it just might mean that either somebody didn't register or the Copyright Office doesn't have all of its records digitized. It only has the records from 1978 up to present digitized. Everything prior to 1978, you can also find those records, but you got to use a different source other than the Copyright Office website for some of those records.
And even when they're digitized, it's hard to find everything always, is what I've learned. I think I found it, oh no, and then there's somebody else looked a different way and they were able to find it, so
Yeah,
it's not, yeah.
yeah,
That's why you get an attorney on this.
yeah.
Anyway, thank you guys all
Yeah.
for coming.
Thanks,
Thank you so
guys.
much for being here. We really appreciate it. Thank you. I'll stop the recording now. Yeah. And thanks everyone at home. I'm gonna go ahead and stop the recording so I can. There.